Good morning everyone. Today's video, we're going to discuss the revised rules of criminal procedures, Rules 119 from Section 23 to 24.
Good day everyone, Section 23, Demeritor Evidence. After the prosecution rests its case, the court may dismiss the action on the ground of insufficient of evidence. 1. On its own initiative after giving the prosecution the opportunity to be heard, or number 2, upon demurrer to evidence filed by the accused with or without leave of the court. The term demurrer used when defendant or the accused believes that the prosecution has failed to provide sufficient evidence to prove their case beyond a reasonable doubt. In other words, the defendant is saying that even if the court accepts all the evidence and fact that the prosecution has presented as true, it is still not enough to prove the defendant's guilt. The process can happen in two ways. First is the court itself, upon seeing that the evidence presented by the prosecution is insufficient, may decide to dismiss the case. However, before doing so, it must give the prosecution a chance to argue why the case should not be dismissed. Second, the defendant can file a demurrer to evidence. This is a formal request to the court to dismiss the case due to insufficient evidence. This can be done with or without the court's permission. So, in essence, demurrer to evidence is a request to end the case early because the prosecution's evidence is deemed insufficient to lead a conviction.
Exactly. When the demurrer to evidence is filed with leave of court and subsequently denied, the accused can present evidence in their defense. However, if it is filed without leave of court, the accused forfeits the right to present evidence, and the case proceeds based on prosecution's evidence. Now let's deeper into the legal concept. When a demurrer to defense is filed with leave of court, it means that the accused is requesting permission from the court to challenge the sufficiency of the prosecution's evidence. If the court denies this request, it signifies that the court believes that there is enough evidence for the case to proceed to the next stage, typically the presentation of the defense evidence. In this scenario, the accused is granted the opportunity to present evidence in their defense to counter the prosecution's case. This allows for a fair and balanced presentation of evidence before a judgment is made. On the other hand, if the demurrer to evidence is filed without leave of court, it suggests that the accused is attempting to challenge the evidence without the court's permission. In such a situation, if the demurrer is denied, the accused waives their right to present evidence and effectively submits the case for judgment based solely on the prosecution's evidence. This distinction emphasizes the importance of procedural rules in ensuring fairness and due process in legal proceedings. It also highlights the strategic decisions that parties must make regarding when and how to challenge the evidence presented against them.
The motion for leave of court to file demurrer to evidence shall specifically state its grounds and shall be filed within a non-extendable period of 5 days after the prosecution rests its case. The prosecution may oppose the motion within a non-extendable period of 5 days from its receipt. If leave of court is granted, the accused shall file the demurrer to evidence within a non-extendable period of 10 days from notice. The prosecution may oppose the demurrer to evidence within a similar period from its receipt. The order denying the motion for leave of court to file demurrer to evidence or the demurrer itself shall not be reviewable by appeal or by certiorari before judgment. If the court denies the demurrer to evidence filed with leave of court, the accused may adduce evidence in his defense. When the demurrer to evidence is filed without leave of court, the accused waives the right to present evidence and submits the case for judgment on the basis of evidence for the prosecution.
So next is, if leave of court is granted, the accused shall file the demurrer to evidence within a non-extendable period of 10 days from notice. The prosecution may oppose the demurrer to evidence within a similar period from its receipt. So meaning, when the court grants leave to the accused to file a demurrer to the evidence, there are specific timelines that both the accused and the prosecution must adhere to. First is accused filing of demurrer. The accused, upon receiving permission from the court, must file the demurrer to evidence within a strict and non-extendable period of 10 days from the date of receiving the notice granted them leave to file the demurrer. Second is prosecution opposition. Once the demurrer to evidence is filed by the accused, the prosecution is given a corresponding non-extendable period of 10 days from the receipt of the demurrer. The opposite is, during this time, the prosecution can present argument and evidence to counter the demurrer filed by the accused. So both parties have a fair opportunity to present their case and arguments effectively. When the specific period, the process ensures that the legal proceedings are conducted efficiently and fairly, allowing for a thorough consideration of evidence and arguments presented by both sides.
Denying the motion for leave of court to file demurrer to evidence or demurrer itself shall not be reviewable by appeal or by certiorari before judgment. This statement is a legal provision that essentially means if a court denies a party's request to file a demurrer to evidence or denies the demurrer itself, that decision cannot be appealed or reviewed by a higher court until after the final judgment in the case has been issued. In simpler terms, you can't challenge the denial of a demurrer until the trial is over. In summary, Section 23 provides options for the court to dismiss a case if it determines that the evidence presented by the prosecution is inadequate, either on its own initiative or in response to a demurrer filed by the accused.
24. Reopening. At any time before penalty of the judgment of conviction, the judge may motu proprio or upon motion, with hearing in either case, reopen the proceedings to avoid miscarriage of justice. The proceeding shall be terminated within 30 days from the order granting it. Section 24, Rule 119 of Revised Rules on Criminal Procedure tells us that it is an important procedural provision in criminal cases. It allows defendants to file motions before arraignment, such as motion to quash or for reinvestigation, which could affect the subsequent proceedings. This provision ensures that defendants have the opportunity to address legal issues or seek further investigation before they are required to enter a plea, thereby safeguarding the rights and promoting a fair trial process. Also, reopening of the case after it has been closed, usually due to the discovery of new evidence of the existence of significant legal errors. Reopening a case is a rare occurrence and usually requires a compelling reason, such as the discovery of new evidence that could potentially change the outcome of the case or the revelation of serious procedural irregularities that undermine the fairness of the trial. It's often subject to strict legal criteria and procedures to prevent abuse of undue delay in the administration of justice, and it shall be terminated within 30 days from the order granting it. When we say motu proprio, an official act given without a formal request from another party. For instance, in reopening, Mary sued Peter for an act of lasciviousness, criminal cases of lasciviousness.